You can pick any seat you wish. It's just like church. Everybody takes the back row. That's okay. We want you to be comfortable in this process. Well, good morning, everyone. First of all, can you all hear me? If not, we have hearing assistance devices, and everyone is nodding yes. My name is Pete Cahill, and I'm one of the judges of the District Court. You have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure the jurors who are selected are impartial, the law provides that the court and the attorneys for the parties may ask questions to all prospective jurors, which must be answered under oath. First of all, thank you for filling out and sending back the questionnaire that we sent you. That's a great help to us in knowing a little bit about your background. Your contribution to the important and serious matter at hand is best served by your continuing to answer those questions fully, completely, and honestly. The questions that you'll hear today will follow up on issues from the questionnaire and possibly other topics. Now, after the questioning is over, the attorneys may excuse you from service on this jury, and I may excuse you for what's called cause. In either case, it does not mean that you are not a fair and impartial person, and you should not take offense in being excused. I also ask that you not take any offense in any questions that are asked. To some extent, we must pry in order to explore opinions you might hold and to talk about some experiences that you have had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree, but in the normal course of trial, charges are likely to be added or subtracted. But those are the charges for you to consider today when you are hearing the questions. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. And now I'm going to ask the different attorneys and parties to introduce themselves. So for the state.
Good morning, ladies and gentlemen. My name is Steve Slisher, representing the state of Minnesota.
Good morning, my name is Christina Marinakis, and I'm assisting with the prosecution.
Good morning, everyone. My name is Keith Ellison, and I represent the state of Minnesota.
Good morning, Joshua Larson, also with the state of Minnesota. Thank you.
Mr. Nelson, if you could introduce yourself and your client.
Good morning. My name is Eric Nelson. This is my client, Derek Chauvin, my assistant, Amy Voss.
Thank you. Now, in addition to the attorneys from the Attorney General's office who are here, other attorneys might make their presence known and be a part of the case. Those include Aaron Eldridge, Jerry Blackwell, and possibly and Matthew Frank. Does anyone know any of those attorneys or anybody who works for the Attorney General's office? Okay. And juror number 44, I think we'll deal with that when you come forward for your individual question. Remind us that you have to tell us about the specifics. Anyone know anyone from Mr. Nelson's firm or have any association with them? Okay, everyone's shaking their heads no. Anyone acquainted with anyone else in the courtroom? As you look around, no one familiar, all right. Now, you have been given a copy of a list of potential witnesses. During your individual examination, you'll be asked if you know anybody on that list and the nature of the relationship. So keep that in mind and also bring that list with you when you come into the courtroom later on. Now, one of the things the attorneys may not do in jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in all criminal cases so that you may keep them in mind as you answer the court's and the attorney's questions. So I will instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial, unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now, if you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given their testimony. There are no hard and fast rules to guide you in this respect, but in determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case, the relationship to the parties, their ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity, or the lack thereof, reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case. Also, any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. There are things you should not do during jury selection. You are not investigators. You are not to go out and do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved, the lawyers, witnesses, or spectators. Do not be offended if the attorneys, parties, or witnesses do not speak to you. They know that it would be improper to contact you except through the normal selection process, and so the attorneys and parties will confine themselves to a brief greeting. Now, during the selection process, your family and friends will be curious as to what you are doing, and you may tell them that you are on a panel of potential jurors in a criminal case, and that is all you should tell them. Since that is all you should tell family and friends, that is all you should tell the general public. So, during these proceedings, please refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access those social media tools, but please do not publish any information about this case or your thoughts about this case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about the case, and in particular, do not talk at all to anyone involved in it. Because of the nature of the charges, this case is receiving media coverage. Do not read about this case in the newspapers or watch anything online. Do not listen to news about it on radio or television. This trial, including jury selection, is being televised, but no video of you or any juror will be taken at any time, now or during trial if you are selected. Also, your name will not be used in the courtroom. In order to protect your privacy, you will only be referred to by your random number. The audio of anything you say will be broadcast, unless we need to discuss something that is deeply personal or extremely sensitive or embarrassing, and I specifically order the audio to not be broadcast. In that case, you will still have to answer questions on the record, but without audio or video broadcast. And with that, the exception of juror number 44, I'm going to direct the remaining jurors to follow the deputy back to the courtroom you were just in, keeping in mind that we are exercising COVID protections. So I took my mask off because we are far away from each other, and so that I could be clear. I'm going to be putting it back on when you are in the witness stand for jury selection. Please, while you're in the courtroom, keep your mask on, maintain social distancing, and feel free to use all the hand sanitizers and wipes that you wish. With that, if you could go to the deputy with the exception of juror number 44. All right, juror 44, if you could come on up to the witness stand again. And just for the record, we had a short discussion off the record, or off audio and video. And just so we are clear, we are currently on audio only. We are aware that there's some matters that we are going to discuss with you where we will not only go off audio, but take the extra step of excluding spectators from the courtroom so that only the parties, the attorneys, and a technician who controls our audio and video will be present. Just an advisory there. So before I turn it over to the attorneys, a couple things I want to do is, number one, I have to swear you in to make sure that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I so swear.
All right. Well, first of all, you filled out a questionnaire. Thank you for doing so. You took great care, it appears, to fill it out accurately, and we appreciate that. Is everything true that's on the questionnaire?
Yes.
All right. Are there any changes or additions to the questionnaire that you feel comfortable at this time bringing to our attention?
Just the one thing that we need to discuss off audio.
Right. Okay. And I also appreciate the fact that you kind of marked it very well on the questionnaire, and so we'll abide by your request. All the parties agree on that. At some point, other than that, the attorneys might ask you a question that prompts another recollection, or you may realize an opinion you may have given in the questionnaire has evolved. Maybe it's changed. It's just want you to know that it is all right. In fact, we hope, if it's an honest answer, is that you give a different answer. Mm-hmm. We don't think anyone is lying to us. It's just that things change. People on reflection realize maybe there's some stuff they should have added. So feel free to offer something, even if it is different from what's in your questionnaire. You were not supposed to read any articles or watch media since you filled out the questionnaire, because the questionnaire itself gave that advisory. But we recognize it's been a couple months. You may have inadvertently been exposed to something, a headline, maybe a friend talked to you about the case, and since we told you don't tell anybody that you're a potential juror, you couldn't exactly stop them. So did anything like that happen to you that you became aware of more information from when you filled out the questionnaire until today? And be it a headline about pretrial matters, the parties, anything about the case?
No, I mean, I don't watch local news that much. And I haven't turned it on all week specifically because I knew this was happening. But last week I remember news coverage of, fences going up or whatever around precincts and around this building and stuff. But other than that, that's been it.
All right, yeah. Okay. And the reason why we ask these questions, I'm sure you know, is everybody who's filled out the questionnaire knows something about the case, various degrees of knowledge. And I think almost everyone has formed certain opinions about the case or the people involved. And the question is whether you can put all that aside, because as a juror, you have to be fair and impartial. Part of what is being fair and impartial is that we are all working off the same knowledge base. So in other words, put aside what you've learned outside the courtroom, put aside your opinions. I know you can't put them out of your mind completely, but just not make them part of the analysis. Decide the case just on the evidence that you hear in the courtroom and base it on the law that I give you at the end of the case. Could you do that?
Absolutely.
Okay. Did you recognize any of the witnesses on that long list?
No.
Okay. We did indicate the length of the trial would be about a month. For example, if you were picked on this jury, you would be on your own. Feel free to do anything you want until March 29th. And we anticipate starting trial with opening statements and evidence on that day.
Okay.
And probably it'll last about, and this is an estimate, about 4 weeks.
Okay.
Can you make that work with your personal life?
Yes.
Okay. A little hesitation there. Is there a concern that you wanted to talk about, or?
I'm a single mom.
Okay.
Got 2 teenage boys, a senior and sophomore in high school.
Okay.
They can stay with their dad. I think the first week is actually spring break for them.
Okay.
And so they can be with their dad. And
all right. You will not be sequestered during the trial itself, unless something happens. I have to order,
sure.
and that would be my decision. Right now, I don't see any need for that, so you can go home at the end of the day. We might have some long days, so
Yeah.
you might be a little late getting home. But deliberations themselves will be sequestered. You'll be kept together, put up in a hotel until come to a verdict. Can you make that work?
Yes.
All right. And we've had other jurors express similar issues that they are single parents, but with younger children. It sounds like with teenagers.
They're kind of capable on their own. It would just be that sequestered part that I figured during deliberation we would be.
Yeah, so
I
they could
just
be
wanted
left
to
on
be
their
honest.
own. Sometimes we hope they make good decisions with their teenage brains, but you can pretty much
Yeah,
leave them.
my 18-year-old is not staying by himself.
Sounds like you've already thought through this process.
Either my mom's there or they're going to their dad's.
It sounds like a good decision. All right. Before I turn it over to the attorneys, anything else? Any questions you have for me? All right. With that, before I turn over to Mr. Nelson, just another advisory is when we are doing this, it can become conversational.
Okay.
And in a typical informal conversation, we'll interject with affirmations or even answering the question before it's finished. Because we need a good record of this, we'd ask that you, as much as you can, try not to talk over each other.
Okay.
And I will acknowledge in saying that the lawyers and I are the worst offenders. So, but if we could all try and get to that position, that would be wonderful. With that, as to juror number 44, Mr. Nelson, you may inquire. You may, sure. All right. I think what we're going to do is Mr. Nelson will ask you some questions first, but we are going to go right into some of the more sensitive things.
Okay.
And at everyone's agreement, we are going to go off the audio. The video will simply be of the seal and things like that, not on any of us, so there won't be any lip reading, not that they could with this. But in any case, we will go off audio completely, and we will ask that spectators...